buying a business in the UK, do these 3 things to secure the best deal possible. First, understand who is responsible for the documentation. You, as the buyer, will be expected to produce the board minutes, general meeting resolutions, and the sale and purchase agreement. As a solicitor, I would advise to use this as an opportunity to include clauses that are very much favorable to you. The sale and purchase agreement is always going to be negotiated, and if the seller is not agreeable, the relevant clause can always be reduced in scope. To learn more about sale and purchase agreements, we've linked a video in the description below. Second, understand the difference between share sales and asset sales. In a share sale, you're buying 100% of the shares and the whole company comes with it. In an asset sale, you're cherry picking the assets that you want and only buying those. If you're a buyer, you might want to consider an asset sale. This is because it avoids you taking on hidden liabilities and it minimizes your risks. If you'd like to learn more about the difference between share sales and asset sales, I've linked a video in the description below. I'm Malcolm Zoppi, a qualified solicitor and the managing director of GZ Legal. GZ Legal is a corporate and commercial law firm specializing in drafting commercial contracts and helping with acquisitions. Third, know about seller financing. Seller financing allows you to buy a business with no money down. Usually, the buyer will use the money generated by the business that they've just acquired to pay back the seller. If you're interested in seller financing, I would advise to speak with the seller as soon as possible about this option. To show that you are serious about the purchase, present your offer in the form of professionally drafted heads of terms. If you'd like to learn more about seller financing and how to buy a business with no money down, I've linked a video in the description below. The last thing that you should be aware of before buying a business is that the legal principle of caveat emptor applies. Caveat emptor is Latin for buyer beware, and that means that the buyer is responsible for satisfying themselves with their purchase, meaning they are responsible for conducting their searches and inquiries to make sure that they're making the right decision. For this, it is always advisable to have legal advisors conducting due diligence on the buyer's behalf. Thanks for watching. Check out the rest of the channel, which covers a range of legal issues that are relevant for small businesses in the UK. If you're interested in a free legal advice call, visit our website. It's linked in the description below.